Hi everybody, attorney Nouvelle Gonzalo here with Gonzalo Law, offices in Gainesville, Florida and Cleveland, Ohio. We practice U.S. and international corporate law, as you guys know, but today I want to talk just a little bit about copyright and the difference between copyright and trademark. Now everybody, this subject in and of itself can go on for a couple of hours. I'm just going to give you a quick tidbit on the difference when it comes to how you're registering it and then later on how it's enforced. And that is that trademark, like patent, is what is called jurisdictional. So when you are registering a patent and or a trademark and it's in a different country, so we're talking about international copyright or international trademark or IP law, it's important to keep in mind that this is going to be jurisdiction by jurisdiction when you're talking about trademarks or patents. So that means if you have a trademark in the United States, that does not give you coverage automatically for people who use it in the UK or people who use it in China. You have to then register in those countries, country by country, to make sure that you have protections for that particular trademark. And that's very important to know because we've had people call in that say, hey, I've got a trademark, but someone's using it in the UK. Well, and my question then is, are you registered for your trademark in the UK? And they might often will say no. And so when that's the case, then we have to make sure that then we register in those jurisdictions. So now that does not mean you go and have worldwide trademark registration. That's a very expensive and involved endeavor, but you go jurisdiction by jurisdiction. So the countries that you think are going to be maybe the most problematic or have the most issues with people potentially infringing, then you want to register with them. Now I want to turn our attention to copyright. We talked a little bit about how trademark and patent are jurisdiction by jurisdiction, but what about copyright? Oh my goodness, it's fantastic. Copyright makes it a lot easier because actually that is covered by multiple different countries. So for example, if you have a copyright in the United States, depending on what country you're talking about, it's very likely that you will have coverage in that other country if they are part of a treaty with the United States that is part of an international copyright treaty. So depending on which country, we'd have to look at which treaty is going to govern that. So that's all I want to keep in mind. If you guys are thinking about doing any type of international IP law, it's important to know which playing field you're working with. Are you working with coverage in the whole world when you're talking about copyright in most cases? Or are we talking about jurisdiction by jurisdiction or country by country when we're talking about trademark and patent? All right, that's it. Take care, guys, and have a great rest of your day. Bye.